appeal in the matter of Skatteforvaltningen and Solo Capital Partners and others.
Good morning, my lords. As your lordships know, this is an appeal by the Danish Tax and Customs Administration, SCAT. It alleges that over a 3-year period from August 2012 to July 2015, it was induced to pay out about £1.5 billion by reason of fraud and misrepresentation. This court is concerned on this appeal with the preliminary issue that was ordered to be tried by Mr. Justice Andrew Baker. And the terms of the preliminary issue can be seen in the judgment of his lordship below. If your lordships have that separately, your lordships will see in paragraph 4, Roman 1 of the judgment, his lordship at the end of paragraph 4, Roman 1, his lordship says this is the judgment on the first trial, the revenue rule trial. That's the description that was given to it. And the issue is, are any of SCAT's claims, as alleged, inadmissible in this court under the rule stated as dicey Rule 3? If so, which claims are inadmissible and why? His lordship framed it as alleged. His lordship wasn't envisaging, of course, that there would be findings of fact at this stage. And dicey Rule 3 is helpfully then set out at the top of that page. Your lordships will also find it, if your lordships want it, in the principal authorities, PA 11, 105, page 3. And dicey Rule 3.1, English courts have no jurisdiction to entertain an action 1 for the enforcement either directly or indirectly of a penal, revenue or other public law of a foreign state, or 2, although we're not concerned with that on this appeal, founded upon an act of state. Although it was described as the revenue rule, your lordships will have seen that the issue rather expanded because the respondents also rely on the other public law of a foreign state, the sovereign powers argument.
Also, although the rule is framed as no jurisdiction, certainly some of the authorities, I think including Lord Gough in Norway case, put it on the basis not of absence of jurisdiction, but judicial discretion or restraint, not to exercise a jurisdiction that the court would otherwise have. Precisely
so, my lord, and I'll take your lordships to the Norway case, which is the governing authority on that issue. If your lordships want to see the terms of the preliminary issue, and I don't think it's necessary to take time on it, it's in the supplementary bundle 1, tab 9, at page number 4. At paragraph 19 of his lordship's judgment, his lordship said that, and I quote, the point, this is line 4 of paragraph 19, the point raised on dicey Rule 3 is ultimately a narrow one. And we respectfully agree, despite the mass of documents that are before the court, including the authorities, we agree. And I'm going to focus in my submissions for SCAT on what we say about what we see as the central issues of law that are raised by this appeal. After my submissions, my friend Mr. Feely is going to address specific points on the pleadings, if necessary, and on the distinct position of ED and F-man. I'm going to leave Mr. Feely to address those points.
It's one of the points we were going to raise with you. We can raise it with Mr. Feely. We would like to understand how the case in relation to ED-F-man is put.
Indeed. Well, Mr. Feely is going to deal with that. He's going to deal with it after I've made my submissions. One preliminary matter, my Lord the Chancellor asked us to explain the size of the supplementary volumes, why they were filed so late. I hope that a letter reached your lordship.
We had a very helpful letter,
Well, I'm grateful.
and we fully understand.
Well, I'm very grateful.
It doesn't explain why we've got as many bundles and authorities for a very narrow point. That's a different issue.
Well, I'm going to refer to some of them. They're not all my authorities. In fact, most of them are not my authorities. But understandably, your lordships may think on a case for all parties of this importance, the parties are anxious to have available material that they may wish to rely on. But there it is. The context, can I deal very, very briefly, because, as I say, Mr. Feely's going to deal with those factual matters, and the judge has set out very helpfully the context in which these issues of law arise. He's explained that under the Danish Withholding Tax Act, Danish companies are obliged to withhold 27% of dividends paid to a shareholder and to pay that sum, that 27%, to SCAT by way of a dividend tax. And a foreign resident, that's a non-Danish resident, may be entitled under the Danish legislation to a refund of such withheld tax by reason of the double taxation treaties that have been entered into by Denmark with other states. And our main allegation is that the refunds were paid out by SCAT in response to fraudulent representations of fact by what Mr. Justice Andrew Baker described as paragraph 10 of his judgment as the Solo, etc. Applicants. Our case is that those applications involved false claims that the applicants were shareholders in Danish companies, that the companies had withheld tax in respect of dividends paid to such shareholders. Our case, which of course we will need to prove at trial, is that the applicants did not hold any relevant shares.
It's not that the Danish companies didn't exist or that they hadn't issued dividends and withheld tax. It's that your case is that these respondents fraudulently misrepresented that they were shareholders on whose behalf dividend had been withheld in order to extract money from the SCAT.
They were not shareholders. They did not have any dividends in relation to the companies, and there was no tax withheld. That's our case. And we say, in relation to ground 1, that these Solo, etc. applications were a fraud. That's our case. In relation to ground 1, we are confining our case to fraud because we think we can prove that, and that makes the issue simpler for the purposes of the revenue rule, as I shall seek to explain. We do proceed against ED and F Man, against whom we make no allegation of fraud under ground 2, which relates to the recast regulation. And my friend Mr. Feely, as I've said, is going to address the circumstances relating to ED and F.
The judge thought that the rule might not apply in cases of mistake of identity. But if the question is whether somebody is or is not a shareholder, and they made a mistake in that regard, that's pretty close.
Well, I respectfully agree. That's one of our points, that the judge accepted that in those circumstances there would be the possibility of bringing a claim. And we say that the judge has made he's made a fundamental error of law, because he's failed to recognise that the revenue rule only applies in circumstances where the claim is to recover tax that is due.
Yeah. I mean, what the sentence suggests is that if the fraud had been misrepresenting that they were a particular shareholder who did hold shares, the judge seems to think that that's, in a sense, a case of mistaken identity, albeit one that's fraudulently induced.
Well,
that would be outside the rule, and yet what the American judge describes as whatever it is, common garden fraud.
Yes.
isn't.
Well, I respectfully agree. I'm going to come to that. But that's an important part of our case. There are two issues before the court arising out of the preliminary issue of law. The first, under ground one, is whether the judge erred in law in concluding that these claims by a foreign tax authority cannot be pursued by reason of Dicey Rule 3. The judge refused us permission to appeal, but Lord Justice Mayles granted such permission to us. And the second issue in the appeal is in relation to the judge's finding in relation to the Brussels recast regulation. The judge agreed with us that our claims are civil and commercial matters within the scope of Regulation 1, Article 1 of the regulation. His Lordship nevertheless held that Dicey Rule 3.1 does apply, can be applied, because the regulation deals, he said, with jurisdictional issues and does not prevent, he concluded, does not prevent a state from applying its own rules of policy, such as Rule 3.1. We say the judge erred in law in relation to whether Dicey Rule 3.1 applies, and there's a cross appeal by the respondents who say that the judge was wrong to conclude that these are civil and commercial matters. But I'll come to ground two in due course this afternoon. So can I turn to ground one? The judge's conclusions can be found in particular at paragraphs 118 through to 120 of his Lordship's judgment. And what his Lordship found in paragraph 119 in the sixth line of that paragraph is that our claim against the withholding tax refund applications for the withholding tax refund to be returned is in substance a claim to tax. And at 120, his Lordship found, again in substance, our claim seeks indirectly to enforce here Danish revenue law. And therefore, his Lordship concluded, we fall foul of the revenue rule. Our answer, which I shall develop, is that the issue under the revenue rule is not whether the claim now being made arises in the context of tax. The revenue rule prevents and only prevents a claim being made which directly or indirectly is for the payment of tax which is due. And in this case, we are not seeking to recover due and unpaid dividend tax, or indeed any tax that's due. And the reason why that is so is because the foundation of our argument is that in these cases, there never was a liability to pay tax. There were no shares, no dividends, no tax, no withholding of tax. On the contrary, our case, which we need to prove at trial, is that the sums paid out were induced by fraudulent misrepresentations when there was no tax due, no tax withheld.
Forgive me if I'm being a bit slow, but doesn't one need to go back one step? Because by definition, as my lord has said, there was tax, it was paid, it was withheld, and it went. But that's not what, when you say your claim is not for repayment of tax, what, as I understand it, what you're really saying is you're not concerned with that mechanism of enforcement because that's been done, hence no unsatisfied claim.
Yes, we recovered all the tax that was due under the Withholding Tax Act from other people. We're not seeking by these proceedings to recover any tax.
There's no unsatisfied demand for tax. in contrast, for example, to the McVeigh case,
Yes.
the Irish case.
Yes, indeed. And I'll come to that. In the Irish case, there was a liability.
Yeah. Well, there was
It
an
was a
unsatisfied
liability.
demand for tax
Indeed.
that he hadn't paid.
Indeed. And this case has nothing to do with any demand. These respondents, the persons in respect of whom applications were made, the applicants for refunds, did not have any shares, they did not receive any dividends, there was no dividend withheld, and there's no liability. This case is, we say, is nothing to do with a claim to recover tax which is due. Tax was due from other people, we did recover it, and these respondents, by the alleged fraud, managed to extract from the Danish revenue large sums of money, which it is true was money that was obtained by tax obligations of a general sort, including with withholding tax. But there's no unsatisfied tax claim under Danish law that we are seeking to enforce directly or indirectly by the claims in these proceedings. Indeed, the judge himself accepted on our case that is so. Paragraph 101 His Lordship sets out one of our arguments, that as a result, none of the proceeds of the present action will go to discharge any such tax or any other public liability in Denmark. The judge says, I agree that a recovery now from a withholding tax refund applicant or from a defendant who was not the applicant, where the applicant never had a primary tax liability under the Act, cannot discharge such a liability. And that's our case.
What the judge is doing, perhaps rather ironically, is that he's looking at form rather than substance. Because he's saying this arises from a form that reclaims tax.
Yes.
It's therefore a tax refund claim. And it seems to me this arguably starts to go wrong when he says all the claims must derive from the Act, the WH 83, paragraph 83. The Act provides the foundation for every claim made.
Yes.
And in 86, cause of action starts with and must be pleaded by the reference to delivery.
Yes.
With respect to the judge, I don't understand that. You can say, you've got our money,
Yes.
give it back.
Yes.
They have to say, oh no, we were claiming back withholding tax.
Yes.
But the judge seems to be here looking at it almost like a sort of Tinsley and Milligan approach to who has to plead.
Well, also, there's the sort of curious logic that somehow if this is all on the hypothesis this claim is proved at trial, but
Yes, of course.
if one assumes that there's been a fraud, if they defrauded any other government department in Denmark, there would be absolutely no case whatsoever that Rule 3 applies. Merely because it happens they've defrauded the tax authority.
Oh, precisely. Precisely.
That somehow makes all the difference.
Well, it only makes the difference if the fact that the fraud, the alleged fraud, is committed in the context of taxation is sufficient to bring the matter within the revenue rule. And our case is on the authorities. That is not sufficient. It has to be shown that the claim is a claim which is for, directly or indirectly, tax which is due. And the fact that you commit a fraud, if you do, in the context of taxation, does not bring it within the revenue. As your Lordship says, it makes no difference whether it's the Danish Revenue Administration or the Social Security Department or the department that's dealing with COVID payments out to companies. It makes no difference. That's the issue. And I say that's well established by the authorities. And it is perhaps because the respondents have recognised the difficulties in bringing their case under the revenue rule that they also now seek to rely, and it's true they did rely below also, on the broader concept of sovereign powers within the scope of Dicey Rule 3.1. I say that was not the basis on which the judge decided the case, although there are certainly references to sovereign powers in the judgment. But I say the judge dismissed the claims on the basis of the revenue rule, and I've taken your lordships to 118 to 120. There's also the coda, as his lordship calls it, at starting at 121, and I draw attention in particular to 129, referring
You say though that you can't bring a claim for defrauding a revenue.
very strange. In our submission, it's very difficult to understand why that should be the position, unless it is a claim to recover directly or indirectly tax that is due.
Talking about defrauding the revenue rather begs the question, because it could be defrauding the revenue department, or it could be defrauding revenue. So if you siphoned off tax before it got to the government, you could see that different arguments might arise.
Well, I can see that.
It's rather like where if a bank pays against a forged cheque, saying the bank is somehow claiming on the cheque, or is claiming as a bank. It's not, it's claiming as a party who's paid out money that it shouldn't have paid out.
Well, it's suing as here we're suing as the bank would be suing, or the private individual who's the victim of an alleged fraud. It makes no difference. I'll come on to the sovereign authority argument, but we say again, this is not an attempt here by us to enforce any sovereign power. We're as entitled as any private party to seek damages or restitution when monies have been obtained from us by fraud, if we can prove that. And again, the fact that the alleged fraudsters used the tax system as the vehicle, the means by which to implement their fraud, does not make these claims to recover sums of money an exercise of sovereign authority. We say that if and to the extent that we've exercised sovereign authority by making the original refund payments, the claim that we are bringing in these proceedings is not a claim seeking to enforce or vindicate such an exercise of sovereign power. On the contrary, we're disavowing such payments as induced by fraud. But I'll come to the authorities on sovereign powers. There's also on the authorities a recognition that the broader sovereign authority principle, unlike the narrow revenue rule, is subject to a public policy exception. And if we get there, we say that there's a very strong public policy reason for allowing these claims to continue. The court will not allow the respondents to escape liability for their fraud if it can be proved. The skeleton arguments for the respondents contend that we're asking this court to reconduct an evaluative exercise conducted by the judge. That's not what we're asking the court to do. We're saying there are errors of law here, and we can either satisfy the court that they so, or we can't. This is not an evaluative exercise. And
either the judge has, as it were, overstated the principle or given the principle too broad a scope, or in applying the principle, if he stated the principle correctly, he has misapplied it. Either way, it's an error of law.
And your lordships will see the authorities, none of them adopt the approach that the appellate courts will recognise this is. The appellate courts say this is either on one side of the line as a matter of law, or it's on the other side of the line. Can I then turn to what we say are the relevant principles concerning the revenue rule, dealing with that first? First, the nature and purpose of the rule. And my Lord the Chancellor has already referred to this, but it might be helpful just to have in mind what Lord Gough said. It's in the principal authorities, PA, Volume 1, at tab number 6. This is the Norway case. PA1, Volume 1 of the Principal Authorities, tab number 6, the state of Norway's application. And this is the case where the state of Norway is seeking the assistance of the English court with regard to the oral examination of witnesses in the context of tax litigation or litigation concerned with tax in Norway. And the relevant paragraph as to the nature of the exercise appears in the speech of Lord Gough for the appellate committee. And can I pick it up, please, at page 807 of the report, which is page 85 of the electronic bundle. 807. And at letter D, His Lordship says it's necessary to turn to the impact upon the jurisdiction of the principle associated with decision of Lordship's House in Government of India and Taylor. And he then sets out Rule 3. And at E, in that rule, it is stated that the English courts have no jurisdiction to entertain such an action. However, in Dicey and Morris, it's recognised the theoretical basis of the rule is a matter of some controversy. His Lordship refers to what Lord Keith had said in Government of India v. Taylor. One explanation of the rule may be thought to be that enforcement of a claim for taxes is but an extension of the sovereign power which imposed the taxes, and that an assertion of sovereign authority by one state within the territory of another, as distinct from a patrimonial claim by a foreign sovereign, is treaty or convention apart, contrary to all concepts of independent sovereignties. And there's a reference to what Lord Dinning had said in the Ortiz case, and over the page is the passage that my Lord the Chancellor had in mind. It's not necessary for the purposes of the present case to decide what is the precise theoretical basis of the rule, although I am respectfully inclined, said Lord Gough, to agree with Lord Keith. At all events, the rule cannot, in his Lordship's view, go to the jurisdiction of the English court. What the English court does is simply to decline, in such cases, to exercise its jurisdiction, and on that basis, the relevant proceedings will be struck out or dismissed. So that's the statement of principle. And it's not in dispute. The second matter that, again, is not in dispute is that the Dicey rule, Rule 3.1, is concerned with direct or indirect enforcement in this country of the revenue laws of a foreign state. That's what Dicey Rule 3.1 says for the enforcement. What the rule does not prevent is recognition of the revenue laws of a foreign state. The court frequently has regard to, recognises the revenue rules of a foreign state. Indeed, the Norway case is a very good example of it doing so in deciding that there was no problem about assisting the Danish courts in the tax context. And indeed, the judge below, Mr. Justice Andrew Baker, accepted that that principle is so in paragraph 17 of the judgment. It's 17 Romans 6, my lords, where his lordship says there is a distinction between mere recognition of foreign penal revenue or other public laws or sovereign acts, including recognising the effects or consequences of the past exercise of sovereign power in the sovereign territory, for example, vesting of title to property by an act of expropriation completed in the territory of the expropriating sovereign on the one hand, and enforcement on the other hand. Dicey Rule 3 is not designed to preclude or prohibit the former. And we respectfully agree there's a lot of authority that so states, including Dicey, Morrison Collins itself, in particular, paragraph 5-024, which is at Authorities 11, PA 11, Principal Authorities 11, at tab 105. But I won't take time on that because I don't understand it to be in dispute. It is elementary. Next, we say that the revenue rule on the authorities is concerned with claims by a foreign state to recover, directly or indirectly, taxes that are due under its laws, irrespective of the form of the action. And can I take your lordship to what we say are the relevant authorities on this? The starting point is Government of India and Taylor, which is in Principal Authorities 1, Principal Authorities Volume 1, PA 1, and your lordships will find the Government of India case at tab number 4. And the head note identifies the context, PA1, tab number 4, if your lordships have that. In the head notes, the Government of India was seeking to prove in the voluntary liquidation of a company registered in the United Kingdom but trading in India for a sum due in respect of Indian income tax, including capital gains tax, which had arisen in India. So that's the context. A claim for sums due by way of tax. And Viscount Simons, who gave the first judgment, first speech, beginning at page 503, just under the lower hole punch, beginning of his speech.
Can we have the electronic page number?
Yes, it's PA 1, it's
13.
tab 4, page 13.
Thank you.
And on page 13 of the electronic bundle, in the middle of the page, your lordship see Viscount Simon's speech begins. The questions raised in this appeal are two, and it's the first we're considering, whether there is a rule of law which precludes a foreign state from suing in England for taxes due under the law of that state. That's the issue, that's the rule that is being considered. At page 509, electronic page 19, Lord Morton and Lord Reid concur. At the bottom of that page, electronic 19, Lord Keith then gives his speech fully concurring with Viscount Simons, who's held that there is such a rule. And Lord Keith refers, and my Lord the Chancellor referred to this, to the Buchanan and McVeigh case in Ireland. And his lordship then goes on in the 8th line. It illustrates two propositions. There are circumstances in which the courts will have regard to the revenue laws of another country. In no circumstances will the courts directly or indirectly enforce the revenue laws of another country. And at the bottom of the page, this is page 20 of the electronic volume, his lordship explains in the third line from the bottom the context of Buckingham. It was in substance an attempt to enforce indirectly a claim to tax by the revenue authorities of another state. At the top of page 21 of the electronic bundle, page 511, there's the passage that I read from Lord Gough's speech in the third line and following. I won't read that again. Then we have Lord Somerville, whose speech begins on page 23, just under the lower hole punch, and his lordship at page 24 of the electronic bundle, in the first new paragraph in the middle of the page, says there's no decision binding on your lordship's house. The matter therefore falls to be considered in principle. If one state could collect its taxes through the courts of another, it would have arisen through what is described, vaguely perhaps, as comity or the general practice of nations inter se. The appellant was therefore in a difficulty from the outset. So again, his lordship is contemplating a claim to collect taxes. If your lordships then look at the Buchanan case itself, referred to by Lord Keith, that can be found. It appears in the law reports immediately following Government of India and Taylor. We have it in Principal Authorities, Volume 7, at tab number 47, electronic page 1. PA 7, stroke 47, stroke 1. And this is in the appeal cases, attached as a note to the speeches in Government of India and Taylor. And it's a case, if I can summarise the head note, where the claim was indirectly to enforce a tax obligation, tax due in a foreign state. A businessman in Scotland had entered into a scheme to avoid a retrospective tax. He'd moved to Ireland. And we see that at page 517, page 2 of the electronic bundle in the third new paragraph, beginning retroactive legislation. At the end of that paragraph, he devolved a plan swift and simple. He would secretly dispose of all the valuable whisky stock scraped together with his private assets to safe hands in Ireland. In due time, he'd follow his money to this jurisdiction, from where he was advised he might safely snap his fingers in the face of a disgruntled Scottish revenue. And the disgruntled Scottish revenue took action. They took action to wind up his company. We see that at the end of page 4, page 519 of the report, page 4 of the electronic bundle. They got wind of what was going on. They made an assessment on the company for £370,000 in respect of excess profits tax and £15,000 in respect of income tax. Those assessments were confirmed on appeal, and a petition was then issued at the suit of the Lord Advocate, suing on behalf of the Scottish Revenue to wind up the company compulsorily, and that's what the Scottish courts did. They wound up the company, they appointed a liquidator, and that liquidator then brought proceedings in Ireland in order to recover the sums that were due. And at page 523, which is page 8 of the report, in the penultimate paragraph, there's a reference to this being a fraud on the Scottish Revenue. Plainly, it was. At page 526, which is page 11 of the electronic bundle, Mr. Justice Kingsmill Moore, in the first new paragraph on page 11, summarises the decisions. The decisions establish the courts of our country will not enforce the revenue claims of a foreign country in a suit brought for the purpose by a foreign public authority or the representative of such an authority, and that even if a judgment for a foreign penalty or debt be obtained in the country from which it's incurred, it's not possible successfully to sue in this country on such judgment. At 529, which is page 14 of the electronic bundle, in the first new paragraph, 2/3 of the way down the page, his lordship says, if I'm right in attributing such importance to the principle, it's clear that its enforcement does not depend merely on the form in which the claim is made. It's not a question whether the plaintiff is a foreign state or the representative of a foreign state or its revenue authority. In every case, the substance of the claim must be scrutinised. And if it appears that it is really a suit brought for the purpose of collecting the debts of a foreign revenue, it must be rejected. And leaving out a sentence, for the purpose of this case, it is sufficient to say that when it appears to the court that the whole object of the suit is to collect tax for a foreign revenue, and that this will be the sole result of a decision in favour of the plaintiff, then a court is entitled to reject the claim by refusing jurisdiction. Well, not refusing jurisdiction, as Lord Gough said, that's not the nature of the exercise. My friends for the respondents also emphasise the preceding sentence, the sentence at the end of the first paragraph on that page 14. Safety lies only in universal rejection. Such a principle appears to his lordship to be fundamental and of supreme importance. But that begs the question, rejection of what? And the answer is in the paragraph I read. The answer is rejection of claims by a foreign state, or anyone else, which is directly or indirectly seeking to collect the debts of a foreign revenue, in other words, a claim to tax. And this is also confirmed on the next page, page 15. In the middle of the page, the first new paragraph, in the middle of the page, his lordship says, I hold as a fact, indeed I understand it to be admitted, that the sole object of the liquidation proceedings in Scotland was to collect a revenue debt. And then leaving out a sentence, I hold that the sole object of the present proceedings before me is also to collect a Scottish revenue debt. And that's why the Scottish revenue and indeed the liquidator were disappointed. Mr. Buchanan got away with it, but he got away with it because it was a claim to enforce a tax debt, tax that he owed to the Scottish revenue. The case then went to the Irish Supreme Court, and at the bottom of page 15, page 530 of the report, your lordship see the judgment of the Chief Justice, Chief Justice Maguire, who upheld the decision of Mr. Justice Kingsmill, and his lordship's judgment on the main issue can be seen in summary at page 18 of the electronic bundle, which is page 533. In the first new paragraph beginning, it is argued that, and if your lordships please would go down to the last 4 lines of that paragraph, his lordship says the position seems clearly to be, as found by the trial judge, that these proceedings were started in Scotland with the purpose of collecting a tax, and that apart from costs and the expenses of the liquidator, any monies recovered will inevitably pass to the revenue. And that's why the appeal was dismissed. We accept, this is a point that the respondents emphasise, we accept that the Buchanan case, as approved by Lord Keith in Government of India, supports the proposition that Dicey Rule 3.1 prohibits a claim to collect tax owed, whether it's directly or indirectly being pursued, even where the taxpayer has acted in a fraudulent manner. There's no dispute about that. Fraud is not a defence. It's not an answer, I'm sorry, it's not an answer to the claim being won to recover tax owed. But the contrast in the present case, on our allegation, is that we're not seeking to recover directly or indirectly tax due for the reasons that I've already indicated. And there's a very clear contrast, a distinction of principle between the dishonesty in Buchanan and the dishonesty here. The dishonesty in Buchanan was in seeking to avoid tax due, tax owed. And the revenue, foreign revenue, cannot bring a claim to recover tax due, even if they allege fraud. The fact that the defendant in Buchanan was dishonest did not alter the fact that the claim was seeking indirectly to recover taxes that were due. And that's why the revenue failed. By contrast, in the present case, our claim based on fraud and dishonesty is in circumstances where no tax was ever due and is not now due. So Buchanan does not assist. On the contrary, it assists us in the principles that we have sought to identify. And if there were any doubt about what is the scope of the revenue rule, it is clarified by the appellate committee decision in Williams and Humbert, which can be found in volume 1, PA1, Principal Authorities volume 1, at tab number 5, my lords. And this is the appellate committee in the context of Spanish legislation. Principal Authorities, Volume 1, my lord, and we're looking at tab number 5. Williams and Humbert. And your lordships may well be very familiar with this case, Spanish legislation. The Sherry case, indeed. Spanish legislation had given Spain control over companies and the consequent benefit of trademarks that had been held in trust for the Matias family. And there were proceedings brought against that family where they alleged that the proceedings were an attempt to enforce a foreign law which was penal or which otherwise ought not to be enforced by the court. And Lord Mackay, if I can go to his speech first, Lord Mackay, with whom Lords Scarman, Bridge and Brandon all agreed, addressed the revenue rule they agreed at electronic page 58 and it's page 425 of the report. Lord Mackay's speech begins on electronic page 70, which is page 437 of the report, from Mackay of Clashfern at page 70, and his lordship refers at C to Dicey and Morris Rule 3.1, and at letter G, his lordship says the questions raised in Government of India and Taylor were first, whether there is a rule which precludes a foreign state from suing in England for taxes due under the law of that state. There's then a recitation of what Viscount Simon said on page 71. Lord Keith's speech is set out. On page 72, the Buchanan case is set out. I won't go back to those. There's a reference to other case law, Rossano, Brockow at the bottom of page 72. And the meat of this is on page 73. In the middle of the page, just under the upper hole punch in the printed version, the middle paragraph, Lord Mackay says this: from the decision in the Buchanan case, counsel for the appellant sought to derive a general principle that even when an action is raised at the instance of a legal person distinct from the foreign government, and even where the cause of action relied upon does not depend to any extent on the foreign law in question, nevertheless, if the action is brought at the instigation of the foreign government, and the proceeds of the action would be applied by the foreign government for the purposes of a penal, revenue, or other public law of the foreign state, relief cannot be given. So that was the argument. And then there's a summary of what the circumstances were in Buchanan. It has to be observed in Buchanan the action was being pursued by a person whose title as liquidator depended on him having been appointed by a petition to the court in Scotland on behalf of the revenue. The ground of action was that transactions being attacked in the proceedings were ultra vires and dishonest, because there existed at the time they were effected in Scotland a claim by the revenue which the transactions were designed to defeat. If no such claim existed, the defendant would have been entitled to retain the subject matter of the claim. Most important, I emphasise those words, there was an outstanding revenue claim in Scotland against the company, which the whole proceeds of the action, apart from the expenses of the action and the liquidation, would be used to meet. No other interest was involved. That this was regarded as of critical importance appears from what was said in the decision on appeal by the Chief Justice, and I've read that passage, and I rely on all of that. His Lordship goes on, having regard to the questions before this House in Government, India and Taylor, I consider, says Lord Mackay, that it cannot be said that any approval was given by the House to the decision in the Buchanan case, except to the extent that it held that there is a rule of law which precludes a state from suing in another state for taxes due under the law of the first state. That's the principle in my submission. Very clear principle, well established by what has gone before, but for good measure recognised for the appellate committee by Lord Mackay. No countenance was given in Government of India, in Rossano, in Brockow, to the suggestion that an action in this country could be properly described as the indirect enforcement of a penal or revenue law in another country when no claim under that law, that's the revenue law, no claim under that law remained unsatisfied. And we rely on
Mr.
that.
Panic, I'm trying to follow the presenter screen and set your mind it's well behind you.
I do apologise, my lord. Shall I go back to...
If the screen could just go on to the next page, I can catch up.
That is out of my control. I'm grateful. Thank you, my lord, for mentioning it. I should be following that as well. Country could be properly described as the indirect enforcement of a penal or revenue law in another country when no claim under that law, that's under that revenue law, remained unsatisfied. Again, we say that is the principle. The existence of such unsatisfied claim to the satisfaction of which the proceeds of the action will be applied appears to me, says Lord Mackay, to be an essential feature of the principle enunciated in the Buchanan case for refusing to allow the action to succeed. We rely on all of that. We say that is very clear indeed as to the scope, the purpose, the effect of the revenue law. And whereas in our case, for the reasons I've summarised, there are no taxes due under the law of Denmark, where we're not suing to recover an unsatisfied tax claim.
So just picking up on where this all began at page 440.
Yes.
The report at where he sets out what the appellant's
Yes,
argument
D
was.
to E is the argument.
Between D to E.
Yes.
I mean, he doesn't spell out expressly that it's no answer if there's no claim for unpaid tax or no claim for unsatisfied revenue, however you describe it. It's no answer to say, well, you are pursuing this action, and the proceeds of the action will be paid into the revenue of the foreign state.
That was the argument. The argument
So
was...
that's, and you would say here, it's no answer that SCAT is the tax authority, and therefore, by definition, if it succeeds at trial, the money will go into the revenue, because here there was no unpaid tax.
Precisely. That is the specific argument that was being advanced, and it's the specific argument that is rejected, and it is rejected because, in the opinion of Lord Mackay, with whom 3 of the other members of the appellate committee agreed, it is, to use Lord Mackay's words, an essential feature, unquote, of the Government of India principle that the claim is for unmet tax liabilities, sums owed under the revenue laws of a foreign state. And there's nothing surprising, I say, about that, because that's what Buchanan was addressing. It's what Government of India was addressing. Counsel in Williams and Humbert is attempting to expand the principle and fails to persuade their lordships.
So if it's an essential feature, as Lord Mackay says, then your submission would be that for the respondents to be able to rely on Dicey Rule 3, they have to establish that by procuring the so-called refund, they have in fact regenerated a need for a claim for tax.
Well, they have to show by some means that the claim which is being brought in these proceedings is a claim to meet a tax liability that is owing.
Yeah, but they have to go further. They have to, exactly, they have to create a tax liability, which on your approach they do, or they have to do, by saying we've procured a refund. That means that there is now a shortfall of tax, which is what you're now trying to recover.
Well, their case can only proceed on the basis that by reason of the alleged fraud, the revenue in general has less money than it would otherwise have had.
Because you had got in the tax.
Yes, yes. And the judge at various places in the judgment refers to this argument. It's the whole argument, H-O-L-E. There's a whole which we, SCAT, are attempting to replenish, to recover, to address. But that's not good enough, in my submission. First, because it doesn't address the criteria that are laid down in the case law that I've shown at the court. But there would be a hole in the general revenue take. This all assumes that there's a fund, a specific fund dealing with it. But leaving that aside, the argument also fails because there would be a hole if the respondents had tunnelled into the offices of SCAT and they'd made off with large sums of cash from the safe. There would be a hole. Or if they had, through a computer hacker, they'd hacked into the bank account and simply siphoned off large amounts of money.
This is all about the elasticity of language, isn't it? Because they're defrauding a revenue department, and they're, if I can put it in this way, they're pressing buttons which have got the word revenue on them.
Yes. And
the argument between all of you really is whether that in substance means that they have generated what is a necessary claim for tax.
Yeah.
Or whether they've just defrauded you of some money and please can you have it back?
And that's why I said in respectful agreement with His Lordship that at root this is a simple issue. But I say it's the answer is very plain because there is no tax liability.
Well, that's the point, isn't it? I mean, if you're right, you say, in answer to my Lord's point, that merely by fraudulently obtaining the refund, and you're claiming back that money fraudulently taken away from you, that doesn't generate a tax liability in the respondents, because there never was a tax liability. So they can't create it all you're seeking to do is to get back money that's been fraudulently abstracted from.
Yes, precisely so. There never was a tax liability, and there isn't a tax.
For these people.
For these people.
There was a tax
Yeah, for
liability.
these people. For these.
And it's been satisfied.
Your Lordship's correct, yes. We've taken in all that we are entitled to take in under the withholding tax legislation. It's not merely that there wasn't a tax liability, there isn't now a tax liability. What there is, if we're right, we can prove our case, there is a liability at common law to pay damages restitution for the fraud, for the misrepresentations. But that's a completely different cause of action. This is neither directly nor indirectly to seek to recover tax that is owed by the respondents. The highest they can put it is that their fraud enabled them to obtain sums of money by, on our case, abuse of the tax system. But that doesn't make our claim a claim to recover tax from them. And the judgment in the speeches in Williams and Humbert, I'll come to Lord Templeman in a minute, but I should draw attention to what the judge below said about the speech of Lord Mackay. If we go back to the judgment below, his lordship set out the passages at paragraph 50 of the judgment below. And at paragraph 51, his lordship said that explanation, that's Lord Mackay's explanation of Buchanan and Mackay, Government of India, supports the defendant's argument in this case, subject to the prior question, which is the real question here, whether Scat's unsatisfied claim to recoup what it paid out by mistake is to be regarded for the purposes of Dicey Rule 3 as a revenue claim. Now, it's puzzling in my respectful submission that the judge regarded what Lord Mackay had said as assisting the defendants, because what Lord Mackay said is that it isn't good enough, and my Lord the Chancellor made this point to me for the purposes of argument, it's not good enough that the money would be applied by the foreign government for the purposes of revenue. What's necessary is to show it's an action seeking to recover tax due. And his lordship then says, he refers to the prior question, whether Scat's unsatisfied claim to recoup what it paid out is to be regarded as a revenue claim. But that question has to be answered in my submission by reference to the principle which Lord Mackay has set out. It's only a revenue claim for the purposes of Rule 3.1 if it's a claim to recover taxes that are due. And at the end of paragraph 51, his lordship then says, Lord Mackay cannot sensibly be taken to be expressing a view on the point raised by this case and not raised by or considered in Williams and Humbert, which is whether, as the defendants say, there's no material distinction for the purposes of Rule 3 between a claim for tax due and unpaid and a claim for the return of a tax refund mistakenly granted and paid. And at 52, if the defendants are right about that, then Scat's unsatisfied claims for the return of tax refunds fulfil Lord Mackay's requirement. But that, with great respect, misses the point. Of course, characterisation of the claim is vital, but it is essential in my submission to be clear about the question of law to which the characterisation is addressed. And the question of law is whether the claim in this jurisdiction is seeking, directly or indirectly, to recover tax due under the foreign law. And that's not this case. And I say with great respect, the judge misses that fundamental, essential point established by all the authorities.
As far as the whole point is concerned, it's difficult to reconcile the
judge's position with what he says in 84. He seems to think that if there was a cyber attack or spawning of an employee, that wouldn't be caused by the rule.
No, indeed, and the claim would be a claim.
There'd still be a hole in the revenue.
Yes, there would be the same hole, and it would be the same attempt to replenish that which had been taken from the revenues funds.
But what if the suborning of the employees to pay out on a fraudulent claim for a tax refund?
Well, I respectfully
And
agree.
it seems to me it's exactly the same situation, only with an added element of bribery.
Indeed. And as your
So
lordship,
the fraud, the suborned employee who, in your example, leaves the door open so they can
Yes.
raid the safe. What's the difference in principle between that and the suborned employee who helps them with paying out the fraudulent refund?
indeed, all these examples, and indeed the identity example, which my lord put to me earlier this morning, they all can be answered by addressing the principle which the authorities support, which is, in substance, not as a matter of form, but in substance, is the claim a claim to recover taxes that are due under the foreign revenue law? Either they are or they're not. And if that's not the nature or the substance of the claim, the revenue rule simply doesn't apply to any of these circumstances.
This may be just simply show how far off the pace I am, but if someone came into the revenue department and took a sack of money, what would the necessary connection, okay, just leave that as one, but what we're dealing with is people who make applications for refunds asserting that they are connected with company D. Is that sufficient to create a link between the claim and what is actually paid out? Why is what is paid out to be regarded as attributable to company D in any way, and does that matter?
Well, your lordship identifies one of the contexts in which the judge himself recognised that the revenue rule wouldn't apply. That's mistakes of identity. That SCAT makes a refund to Mr. X, intending to pay it to Mr. Y, and the judge accepts that in those circumstances there would be a very strong argument that the revenue rule has nothing to do with it. You're seeking to get back money that's been paid out by mistake, particularly if there's a fraudulent misrepresentation by the individual. But again, my answer to your lordship is that there's no inhibition. The law does not prohibit a foreign revenue authority from suing to recover sums of money that have been wrongfully obtained from it. What it prohibits is the foreign revenue authority attempting to use the courts of this country to recover, directly or indirectly, taxes that are owed and which have not been paid.
But it's something slightly more fundamental here, is it? The judge seems to regard these payments as in some way tax refunds. But there's a claim for a tax refund, but just as a forged cheque isn't a cheque,
Yes.
a fraudulent claim for a tax refund is not a claim for a tax refund. Everything here is a nullity. Fraud unravels all.
Well, indeed.
And any number of aphorisms we use, there just simply isn't anything to do with tax or claiming tax back. It's a fraudulent representation to extract money from somebody, which is successful. So we're not, it seems to me we're not, on that basis, we're not within the tax regime at all.
We are only within the tax regime to this extent that the respondents on our case have used or abused the tax system as the means by which to obtain money from SCAT. We're within the tax system in that sense, but I respectfully agree with your lordship. On our case, if proved, these are not even refunds.
Well, I don't want to keep coming back to my own example, but it's like saying that the bank has honoured a forged cheque.
Yes.
It has not done anything.
Of course.
It's just paid the money out against a fraudulent misrepresentation.
Well, the bank has paid out in the belief, but the belief has been induced by the fraudulent representation.
By the fraud.
Yes. Well, that's our case, and the revenue rule is being used in my submission on these authorities for a purpose that for circumstances that are not merely supported by the authorities but are directly contrary to the authorities. I said I'd come back to Lord Templeman, who gave a separate speech in the case. He dealt much more briefly than Lord Mackay, but to like effect with Government of India and Buchanan. He referred to Government of India at page 432, which is page 65 of the electronic bundle. Page 65 at E to G, and he then turned to Buchanan and then turned to Buchanan, and over the page, at page 66, at just under B, Mr. Lippman, it was Mark Lippman who was arguing this case, relied heavily on the Buchanan decision, which he said applies to the present case because the object of the plaintiffs in the trademark action and the bank's action is to collect assets which will indirectly inure for the benefit of a foreign government. However, in my opinion, the Buchanan case only concerns a revenue claim. The principle that a country cannot collect its taxes outside the territories cannot be used to frustrate or contradict the principle that the courts of this country will recognise the law of compulsory acquisition of a foreign country of assets within the foreign country and will accept and enforce the consequences of that compulsory acquisition. So again, Lord Templeman understands the revenue rule as a rule that a country cannot collect its taxes outside its territory. And I say that's absolutely right. So we say all these authorities strongly support our contention that
he focused on the compulsory acquisition rules and analysed the authorities on that, and those cases where it had been held that the law that was being relied upon was a penal law.
Yes.
And in fact, Lord Mackay says in terms that he adopts the analysis.
Precisely
so.
so.
There's no difference between them.
Precisely so. So my friends, in my submission, my friends have to say that Williams and Humbert was wrongly decided, and they plainly can't do that, certainly at this level. This argument, the argument that we're advancing, has been accepted in the United States Federal District Court. Can I take your lordships to Principal Authorities Volume 7 at stroke 57, PA 7 stroke 57. This is the decision of the district judge in the United States District Court in the claim brought by SCAT. And your lordships will see at PA 7 stroke 57 stroke 3 the identity of the judge. He's the same judge, Judge Kaplan, who's currently hearing Prince Andrew's the case against Prince Andrew. And
this is the Southern District in New York.
Yes, it is. And the judge sets out on page 3, in the last few lines of page 3, what's going on here. The motions now before the court concern the revenue rule, a common law principle that prohibits courts from hearing actions by foreign nations to enforce their foreign tax laws, whether directly or indirectly. And over the page, he says on page 4, the Kingdom of Denmark here claims the defendants defrauded it of millions of dollars by submitting tax refund claims in which they falsely claimed to own stocks of Danish companies that paid dividends net of withholding tax. In fact, the complaints alleged defendants didn't own these stocks, they had no taxes withheld. Nevertheless, the defendants allegedly obtained many millions of dollars in tax refunds. Defendants, relying on the revenue rule, seek dismissal of these actions at the outset. If plaintiffs can prove that defendants never in fact owned the relevant Danish stocks, and the court's obliged to accept their allegations as true for present purposes, the revenue rule would not apply because the substance of the claims would be for garden variety commercial fraud. Accordingly, the motion to dismiss is denied.
I think that's what we would call common garden.
Indeed.
Possibly.
Yeah.
Yeah.
Indeed. So that's what the judge decides. There's a bit more detail at page 11. In the final paragraph, the judge says, and as your lordships know, he's a judge who doesn't mince his words. These actions plainly do not seek direct enforcement of Danish tax law. The defendants attempt to frame them as seeking to recover lost tax revenue, when the only reason the money was lost is because the defendants in effect allegedly stole it. And the only reason it supposedly concerns tax revenue is because the defendant's alleged victim was the Danish tax authority, is too clever by half. And at page 24, there's a lot of detail, but I won't take time on it. The substance of it is at the top of page 24, second line. The claims as pleaded are not ones for tax revenue, but for money stolen from the plaintiff by fraud. Any argument that an action is one for enforcement if it involves the determination that defendants were not eligible for or entitled to tax refunds under Danish law is foreclosed by the case law. Mere recognition or even application of foreign tax law is not the same as enforcement. And finally, at 27, there's in the final paragraph, he refers, Lordship, the judge refers to the US-Denmark Treaty and its provisions for assistance in the collection of a revenue claim. He says that's irrelevant because the plaintiff's claims do not seek to collect tax owed by the defendants covered by the treaty, etc., etc. So we rely on that. We say that's absolutely right. And in Malaysia, for good measure, the Court of Appeal in Malaysia adopted and applied that reasoning. I won't take time on it, but it's authorities number, principal authorities 7 at tab 59, paragraphs 77 through to 86. But it's
One
the
of the
same.
points taken by the respondents is that the Malaysian court was not told about this judge's decision.
Yes.
Is that right?
The position is set out in our skeleton argument in response and in our letter, which is in supplementary bundle 2 at tab 22, and we set out the facts in footnote 5 to paragraph 7 of our supplementary skeleton argument. Can I just give your lordship the reference to that? It's in CB4, core bundle 4, tab 29, page 3, and the substance of it is that the Malaysian Court of Appeal decided the outcome of the appeal in November 2020, and they communicated it to the parties confidentially. And at that time, the judge had not handed down his judgment. Written reasons were not given in Malaysia until May 2021. And the Malaysian defendants then relied on the judgment of the judge below when they unsuccessfully sought leave to appeal from the Malaysian Federal Court. So the court plainly didn't think that the judgment below affected.
So they may not have known about it when they gave their reasons, but they knew about it when they refused permission to appeal.
Indeed, yeah, precisely so. And argument was based upon it, but they took the view in Malaysia not necessary to grant, it's not appropriate to grant permission to appeal. Lords, I noticed the time.
Yeah.
I'm in the court's hands, but there's a 5-minute break that is allocated around now. It's maybe a convenient moment.
I think it probably would be, wouldn't it? So we try and keep it to 5 minutes.
Thank you very much, Lords.
All rise.
to the cinema, isn't it?
Court rise.
I should mention that there's also a decision of the United States Supreme Court called Paz Quantino. I'm not going to take your lordships to it. Can I just make an assertion? It's in Supplementary Appellants Authorities, which is SAA Volume 2, SAA 2, tab 11A, Paz Quantino. And in that case, the Supreme Court was split 5-4. The majority took, and the context, a very different context, the context was whether the US authorities could bring criminal proceedings under the federal wire fraud statute in respect of conduct to defraud the Canadian revenue. People were going across the border with liquor, alcohol that wasn't being declared. And the question was whether or not a prosecution under the federal wire fraud statute was prohibited by the revenue law. The defendants arguing that here this was all in the context of Canadian tax legislation. And the majority took the view that the revenue rule did not apply. And one of the reasons they did so was because the revenue rule is concerned with the collection of tax obligations of foreign nations. But I won't take time on that. I simply refer to that in case your lordships are interested in it. Can I mention the reliance that the respondents place on administrative decisions by SCAT in Denmark, which annulled its prior decisions to accept the refund applications. The judge below did not base his decision on the annulment decisions. There's reliance placed by the respondents in their skeleton argument on these annulment decisions, but they don't appear, this point doesn't appear to be covered by any of the respondents' notices. But I don't want to take a technical point. I'm content to deal with the point on its merits. We say lack of merits. SCAT's pleaded case is that it's not entitled under Danish law to issue any tax assessment or make any other public law decision obliging the respondents to pay back or to pay damages for the refunds in this case. That's our position. It's in the Supplementary Bundle 1, SB1, tab 15, pages 3 and 34. And we deal with this in our Supplementary Skeleton Argument, which is at Core Bundle 4, CB4, page 29, at paragraph 18.1. The proceedings in this country serve the distinct purpose of recovering or attempting to obtain compensation in respect of the funds paid out.
It's not a case where, as it were, as a precondition of pursuing the claimant in England.
No.
You have to have issued some administrative decision in Denmark. That's your point.
No, precisely so. It's not you must exhaust domestic remedies. There's no such principle. Your lordships are concerned in relation to the preliminary issue of law with whether this claim falls within the revenue rule, and for the reasons that I have sought to identify, the claims in these proceedings do not fall within the revenue rule, and whatever the position in Denmark doesn't affect the assessment by this court of the scope and application of the revenue rule in this jurisdiction. That is my submission. I can make more complicated submissions, but I'm content, certainly in opening, to address the matter on that basis. Then there's a...
Is that you would say a complete answer to the point about the exercise of public powers?
Yes.
When we come to that part of the case?
When we come to the exercise of public powers, my answer is that we're not by these proceedings seeking to exercise any public powers.
No.
We are not seeking to enforce any public powers. We're pushing the Respondents case at its highest. We are not seeking to vindicate an exercise of public powers. We're seeking to resile from it. We're seeking to say to this court and to prove that decisions to make refunds were induced by fraud, by fraudulent misrepresentation. But I'll come, if I may, to that. Indeed, I'm coming to that now, the wider rule. So I say, on dicey Rule 3.1, although there's a massive material, although there's a very erudite analysis with respect by the judge, he has, with great respect, missed the point. And the point is a very simple one. And this is not a claim, it couldn't be a claim on our pleaded case, to recover taxes that are due. There are no taxes due from these respondents, there never were, and we recovered all the taxes due from those who owed money under the withholding tax regime. The question then to which I turn is whether there's a wider rule that assists the respondents. And my starting point here by way of submission is that if, as we submit, SCAT is not seeking by these proceedings to enforce a revenue law of Denmark, we're not seeking to recover taxes due, then it would take something very extraordinary, some exceptional circumstances, for a claim by a tax authority to recover sums extracted from it by fraud to be categorised as an exercise of sovereign powers for the purposes of dicey Rule 3. That is, even though the Government of India principle does not apply. This court has recognised that there is a general sovereign powers principle. The case that so decides, I'm sure your lordships are familiar with it, is Umbasogo. And can I invite the court's consideration of Umbasogo, which is in the Principal Authorities volume, PA3, at tab number 22. And the court will see from the beginning of the headnote, the context. The claimants were the head of state of a small mineral-rich African Republic, the Republic of Equatorial Guinea, and the state itself. And they were bringing proceedings against the defendants for inter alia conspiracy and intentional infliction of harm by unlawful means, and the allegation was that the defendants had conspired in England and elsewhere to overthrow the state's government and seize power by means of a coup which ultimately failed. Claimants claimed special damages for damage to the state's commercial interests and infrastructure and for costs incurred in investigating the conspiracy, detaining and prosecuting suspects, increasing security. First claimant claimed general damages for serious anxiety, distress, disruption of his personal life and work as the head of state. Both claimants sought an injunction restraining similar coups in the future. And the judge struck out the claim for damages, refused to strike out the claim for an injunction, and it was held, dismissing the appeal of the second claimant, allowing the cross appeal, that this was an exercise of sovereign authority in the territory of a foreign state, and the courts would not entertain it. And if your lordships then look in the judgment of Sir Anthony Clark, the Master of the Rolls, for this court.
This is the Simon Mann case.
It is. Your lordship may recall that the notorious Mark Thatcher.
Yes, it's Sir Mark Thatcher.
Indeed, Mrs. Thatcher broke down in tears in relation to.
I do remember.
Yes. So it's a case of some notoriety. We respectfully submit as an overarching submission. It's very easy to understand, why the courts of this jurisdiction will not entertain claims for damages or indeed other relief in relation to coups d'etats about which a foreign sovereign state is complaining. I mean, it's not difficult to understand that. It is a very, very long way away from a case in which an organ of a foreign state, a state administrative authority, seeks to recover damages for the obtaining of funds by fraud. I simply make that as an opening point. It's obvious, but I make the point nevertheless. In the judgment of this court, can we please start at electronic page 21, which is page 866 of the report. And at page 21, paragraph 27, there's a reference to the celebrated Emperor of Austria case, which is set out in some detail starting at paragraph 22, but I won't read it all out, 1861. At page 21, paragraph 27, the court says, although the actual decision in Emperor of Austria has given rise to criticism and puzzlement, it is an authority which recognises the fundamental distinction between an action which amounts to an exercise of sovereign authority in the territory of another and an action brought to protect property rights, such as might be brought by an individual. It's this distinction which founded the dismissal of the first two grounds of the bill, which related to the protection of Hungary from revolution, but the upholding of the third ground, which the court viewed as merely relating to the protection of property. The defendant was printing banknotes, you may recall, in this country. It's moreover a distinction supported by Dr. Mann, Francis Mann. In our view, it's a key distinction on the facts of the instant case. And at paragraph, I can turn on to page 25 at paragraph 41. Paragraph 41 refers to the speech of Lord Keith in Government of India and the judgment of Lord Denning in Ortiz. They both sought to explain the rationale for the well-established rule that the courts will not enforce the penal and revenue laws of another country. In short, it's the courts will not enforce or lend their aid to the assertion of sovereign authority by one state in the territory of another, The assertion of such authority may take different forms. Claims to enforce penal or revenue laws are good examples of acts done jure imperii. In each case, it's necessary to see whether the relevant act is of a sovereign character. Penal and revenue laws are assumed to be of a sovereign character. There's a reference to what Dr. Mann said, paragraph 42, where the foreign state pursues a right that by its nature could equally well belong to an individual. No question of a prerogative claim arises. The state's access to the courts is unrestricted. Thus, a state whose property is in the defendant's possession can recover it by an action in detinue. A state which has a contractual claim against the defendant is at liberty to recover the money due to it. If a state ship has been damaged, an action for damages lies. On the other hand, a foreign state cannot enforce in England such rights as are founded upon its peculiar powers of prerogative. Claims for the payment of penalties, for the recovery of customs duties, or the satisfaction of tax liabilities are, of course, the most firmly established examples of this principle. And the court says we agree. There's a reference to a later article by Dr. Mann at the bottom of the page, quoting Grotius. He suggested claims are capable of, and then over the page, page 26, capable of international enforcement if they arise from acts that may be done not only by the king but also by anyone else. And there's a bit of Latin again. We agree. At 45, there's a reference to the Spycatcher Case in the High Court of Australia. And just above letter D, the majority of the court suggested that rather than refer to public laws, it would be more apt to refer to public interest or governmental interest to signify the rule applies to claims enforcing the interests of a foreign sovereign which arise from the exercise of certain powers peculiar to government. They concluded the claim for relief in that case, of course, was about national security, or alleged national security, arises out of, is secured by an exercise of a prerogative of the Crown, that exercise being the maintenance of the national security. Therefore, the right or interest asserted in the proceedings is to be classified as a government interest. As such, the action falls within the rule of international law, which renders the claim unenforceable. And then there's a bit more learning, and on page 28 we come to the conclusions. Paragraph 50. Having heard detailed argument, this is paragraph 50, having heard detailed argument, we are unable to accept Sir Sidney Kentridge's submission, he acted for the claimants, that the views expressed by the Privy Council are wrong. The critical question is whether in bringing a claimant is doing an act which is of a sovereign character, or which is done by virtue of sovereign authority, and whether the claim involves the exercise or assertion of a sovereign right. If so, then the court will not determine or enforce the claim. On the other hand, if in bringing the claimant is not doing an act which is of a sovereign character or by virtue of sovereign authority, and the claim does not involve the exercise or assertion of a sovereign right, and the claim does not seek to vindicate a sovereign act or acts, then the court will both determine and enforce it. That was the broad distinction of principle which the court was seeking to draw in Emperor of Austria. In deciding how to characterise a claim, the court must of course examine its substance, not be misled by appearances. We put the distinction in that broad way, it seems to us to express the rationale behind Rule 3.1. So that's what the Court of Appeal said, and the claims in Umbasogo were held to infringe the rule for the reasons given at paragraph 63, which is on electronic page 31. At paragraph 63, we would therefore hold none of the pleaded claims as enforceable in our courts, just as a claim for taxes is an extension of sovereign powers, so too is a claim for relief, damages and an injunction arising from the claimant's exercise of sovereign power in responding to the alleged attempt coup by the defendants. paragraph 67 on the next page, page 32. In short, paragraph 67, we consider the issue of justiciability turns on the distinction which the Sydney recognised should be drawn between an exercise of sovereign power and an action brought by a sovereign state which might equally have been brought by an individual to recover losses for damage to property. We're of the opinion no part of the claim should be entertained by our courts, since, as we've explained, this action has been brought as an integral part of the second claimant's attempts to protect itself from revolution. The Court of Appeal, this court has returned to this general principle in the Government of Iran case against Barakat. Can I just show the court one passage from that judgment? It's in Principal Authorities, Volume 4, PA 4, and the court will find the judgment at tab 25. So PA 4/25. And this was a claim in relation to antiquities which have been brought from Iran, the government of Iran bringing this claim. Tab 25. And the long and short of it is that the court decided that the sovereign authority, sovereign powers principle did not apply in the circumstances of that case. I won't take time on that. I simply invite the court's attention to what is said at electronic page 36, which is page 57 of the report, but electronic page 36. And at paragraph 1, 2, 3, this court, which was Lord Phillips, Lord Justice Wall and Lord Justice Lawrence Collins, who of course knows a thing or two about this subject, paragraph 1, 2, 3, they say, consequently, the Umbasogo case in the Court of Appeal is not in fact a case involving the attempted enforcement of a foreign public law. Although the court approved the residual category of other public law, the ratio is that a claim involving the exercise or assertion of a sovereign right is not justiciable. That's, says the Court of Appeal, the principle in this case, in this area. Now, we say, again, the answer is with respect a very simple one. It is essential for the respondents to identify which sovereign act they say SCAT is seeking to enforce by these proceedings. And it's not good enough, with respect, for my friends to say the court is being invited to recognise some act of Denmark through SCAT, because there's no objection under Dicey Rule 3 to recognising foreign penal, revenue or public laws. The question is enforcement. It is enforcement that is prohibited.
Well, that's the critical distinction that the Court of Appeal drew in Barakat between Ortiz and that case.
Yes.
Because Ortiz was a case of enforcement. This was not a case of enforcement, it was a case of recognition.
Exactly.
Because the relevant Iranian law, long before
Exactly.
the plundering of the graves or whatever it was, had said these artefacts belong to the state of Iran.
Precisely so. And the claim in government of Iran was a claim to recover property that belonged to the state of Iran. It is true, as a consequence some time ago of the laws of Iran, but the claim was not a claim to enforce those laws. It was a claim to recover property, and it was a claim that could have been brought by any private person. And we say equally here, we are not inviting the courts of this jurisdiction to enforce any public law of Denmark. We, like any person who is the victim of fraud, is entitled to say to the court that our property, our money, has been obtained by the defendants by fraud.
That's quite usefully referred to in paragraph 124. So Baccarat.
Perhaps I should take Baccarat more slowly and go back to principal authorities. Baccarat, yes. So your lordship referred to a particular paragraph.
It's paragraph 124, just immediately after where the highlighted paragraph.
Yes, indeed.
123.
124, the application of the approach of the High Court of Australia, in which it was held that a receiver appointed by the US Federal Trade Commission could sue in New South Wales to recover the proceeds of a credit card fraud. In the sphere of consumer protection, regulatory regimes may serve a public interest, be classified as public law, without constituting a governmental interest of the relevant kind. As a matter of substance, it was a proceeding designed to compensate persons who have been defrauded. Well, I'm grateful. And that's the question. One needs to focus under this umbasogo barakat principle on the proceedings which are being brought. Are these proceedings an attempt by the foreign entity to enforce a public law of that foreign state? And here, no. There was in the past, there's a whole structure of Danish tax law. Refunds were made, although, as my Lord Justice Phillips observed earlier this morning, they are nullities because they were obtained by fraud. But in any event, on our case, in any event, we are not seeking to enforce or vindicate any such payments out. On the contrary, we are asserting that they were payments out obtained by fraud, for which we are entitled under basic common law principles to obtain a remedy, to obtain compensation or restitution. So we respectfully submit that this principle in Barakat and in Basoga is a very long way away from the circumstances of these claims. Dicey and Morris helpfully set out examples of cases where this wider principle would or might apply. It might just be helpful to look at that. It's in PA 11, Principal Authorities 11, at tab 105. Under the general editorship of Lord Collins of Mapesbury, PA 11 105, and the relevant paragraph that addresses the application of this principle is at electronic page 15. And it's paragraph 5-040 at the top of the page, where the learned editors say this: the result of the authorities in the Court of Appeal, that's Umbasogo, Barakat, is that the English court will not enforce a claim based on foreign public law if the claim involves the exercise or assertion of a sovereign right, unless, and I'm coming to this, unless it is contrary to public policy for the claim to be shut out. So there's that further limb in any event. There's a reference to the Iran case, and the statement at the end of that paragraph: the Court of Appeal concluded that exchange control legislation and perhaps export restrictions would so fall. In practice, probably the most important rules falling within the category are those which authorise government interference with private property, whether in the form of requisition, nationalisation or confiscation. That's what the editors envisage is the potential scope of this principle, a long way away in our submission from common and garden fraud.
Yeah, and there's a citation then from Lord Templeman in Williams and Humbert making the point about the distinction between recognition and endorsement.
Precisely so. Precisely so. Our arguments on wider sovereign authority principle are also supported by United States authority, which specifically addresses claims by a public authority to recover sums wrongly paid out in the exercise of official state functions. And they're particularly strong cases because they are cases not involving an allegation of fraud. It's simply an erroneous payment out. But even that is recognised by the New York court as not an assertion of sovereign authority. Can I show you, Lordship, the leading case? It's in PA 7, Principal Authority is 7, and it's at tab number 48. It's the case of Nordrhein-Westphalen and Rosenthal. PA 7, tab 48. And the court will see, this is in the Supreme Court of New York, and it's the appellate division of the Supreme Court of New York. And the judgment explains that the plaintiff in the case was one of the federated states, is one of the federated states of the Federal Republic, then Federal Republic of Germany. And in the second paragraph on page 1, the litigation stems from the enactment by the Federal Republic of a so-called federal indemnification law, which was designed to afford compensation for damages suffered by victims of Nazi persecution. Administration of the law is entrusted to the respective federated states. The defendant, now New York resident and citizen, had formerly been a German national residing within the plaintiff's territory. He had filed a claim with the plaintiff's indemnification office, and he was successful. He was granted 2 awards, the amount of which was paid to him in New York City in 1958. The indemnification law, the public law, section 7, content of which is set forth in the complaint, authorises the denial of a claim, quote, if the claimant, in order to obtain indemnification, utilises improper means, makes, causes to be made or permits to be made intentionally or through gross negligence, false or misleading statements concerning the basis for or amount of the claim. Denial for such reasons is also permitted after determination, and the return of performances already rendered may be demanded. After payment of the claim, the plaintiff received information from which it concluded that in his application, the defendant had intentionally, or at least grossly negligently, misrepresented material facts, and so the plaintiff, through its indemnification office, issued a so-called revocation award, which was served on the defendant in New York, and that revoked the monetary awards granted. Over the page, it gave the reasons for the decision to revoke, and it recited that the defendant was obligated to repay the compensation which he'd received. His answer admitted receipt of an award, but he didn't pay it back, and so these proceedings were brought. The complaint states 2 causes of action, the first founded on the revocation award, the second sounding in fraud. The lower court simply proceeded on the first basis, and we may confine our consideration similarly. The defendant was the actor in the proceedings before the agency whose jurisdiction he attacks. That's the same here. The applications, of course, were made by the respondents. he initiated them by filing in Germany an application which stated that it was being submitted pursuant to the federal law for the indemnification of victims of Nazi socialist persecution. And then there's a bit more detail. And then in the next paragraph, granted such submission, our courts may nevertheless decline.
Sorry, can we go down the page, please?
Yes, I'm sorry, yes. Granted such submission, it's just above line 148.
No.
Granted such submission, our courts may nevertheless decline to recognise determinations of tribunals of foreign countries if they contravene our public policy. And there's a case reference. We find no contravention here. While plaintiff is a sovereign, its aim is merely the restoration of an outlay wrongfully obtained from it. The object of the action is not vindication of the public justice, but reparation to one aggrieved. And then it goes on to deal with other matters. It's a short judgment, but in our submission, a correct statement of principle that where under public law the state pays money to an individual and it has cause to believe that the sums were wrongfully obtained, an action to recover the money is not a sovereign act. It's not a vindication of sovereign authority. It is rather an action to recover sums which the defendant was not entitled to. And that is in a context where the court was not even considering an allegation of fraud. It was simply an allegation of a wrongful payment. And we rely on that as assisting our argument that the present proceedings are not proceedings to seek to enforce a sovereign act. That judgment has been more recently referred to in the same volume, PA7, at tab 55, PA7/55, the case of Harvardsky and Kozini, again in the appellate division of the Supreme Court of New York. This is a more complicated case because the defendant had been ordered by a Czech criminal court to pay compensation to the victims of his fraud, and one of the victims brought proceedings in the New York courts seeking enforcement of the criminal court's judgment. And the defendant resisted the application on the basis that New York courts should not enforce foreign penal judgments. And the New York court said it was doing no such thing, but it cited with approval the case I've just shown you, Nordrhein, Westphalen and Rosenthal. It did so on electronic page 3. In the left-hand column on electronic page 3, about 2/3 of the way down the page, there's a sentence beginning, indeed this court. Yes, on what is on the screen, there's a reference to Mahosel and Tribble damages, and just after that, indeed, this court has applied this test in an action that likewise sought to recover monies obtained by fraud. Of course, that wasn't the basis of the decision. We observed that even though the plaintiff was a sovereign, its aim is merely the restoration of an outlay wrongfully obtained from it. The object of the action is not vindication of the public justice, but reparation to one aggrieved. So the court in 2014 has cited with approval the principle that it stated in the Rosenthal case, and we rely on that. My Lords, in any event, if there were, in this case, to be the possibility of the application, contrary to our submissions, the application of a wider exercise of sovereign power rules in Dicey 3.1, there is a limitation on that wider sovereignty principle. The court will not decline to hear the substance of the case if there is a public policy reason to do so. And I've already referred, your lordships, to Dicey and Morris and Collins, which says that. It was in PA 11-105. Just give your lordships the reference again. I won't take your lordships back to it unless your lordships want to go back to it. It was 11-105, and the relevant paragraph is on page 15, electronic page 15, unless it is contrary to public policy for the claim to be shut out. And this court recognised in the Iran case that there is such a limitation on this principle, public policy. The court so recognised in the Iran case. If we could please go back to that. It was PA 4. At tab 25, PA 4/25, and the relevant paragraph, relevant analysis of this begins on page 42 at paragraph 151. If we are wrong, says the court, in the view that this is not a claim to enforce foreign public law, then we do not consider that it should be precluded by any general principle that this country will not entertain an action whose object is to enforce the public law of another state. Why was that? Because, see paragraph 154, further down the page, in our judgment, there are positive reasons of policy why a claim by a state to recover antiquities which form part of its national heritage and which otherwise complies with the requirements of private international law should not be shut out by the general principle invoked by Barakat. Conversely, in our judgment, it is certainly contrary to public policy for such claims to be shut out. A degree of flexibility in dealing with claims to enforce public law has been recommended by the Institut de Droit International, particular where it is justified by reason of the subject matter of the claim and the needs of international cooperation or the interests of the state concerned. So public policy is relevant here in deciding, when the court decides, whether it should decline to hear a case that falls within this more general principle, if it does. And in this case, the judge below did not accept that there was such a public policy dimension. His lordship dealt with it at paragraph 92. And at paragraph 92 of his lordship's judgment, he said it follows that it does not matter whether in principle a scat submitted by reference to Barakat, arguments of public policy can be raised against the application of Dicey Rule 3 to a case for type falling within its scope, or whether, as the defendants submitted, the rule is absolute, i.e. the relevant rule of public policy is that claims of such a character as fall within the rule are never admitted. The only countervailing public policy suggested was that of combating or giving redress in respect of fraud, yet that has never ousted the rule or prevented a type of claim from falling within it that otherwise would. For completeness, I venture to suggest that the proper role for a public policy argument of the kind considered obiter in Barakat, but also with the authority of Dicey, Morris and Collins, is only in assessing whether Dicey Rule 3 is to be extended to a category of foreign public law or species of prerogative or similar power not covered by existing authority, where by reference to the type of foreign law or power being considered, dicey Rule 3 applies, it would be, and there's some words from Buchanan, unwise to attempt to discriminate between those claims which the courts would and those which they would not enforce. Safety lies only in universal rejection. With great respect, there's confusion here. We respectfully accept that within the scope of the revenue rule, the narrow revenue rule, there is no public policy exception. If, contrary to our submissions, by reference to Government of India, Buchanan, Williams and Humbert, if the court were to conclude that the revenue rule does apply, then it is not open to us to rely on public policy. The public policy is that the court will not enforce the revenue law of the foreign state. And I accept that. However, if the respondent's case is being presented under a broader category, umbasogo barakat, there is a public policy exception or qualification, however one wishes to put it. That exception qualification is recognised in Barakat, it is recognised in Dicey, Morris and Collins. The judge, in my respectful submission, is confused in his analysis essentially for that reason. The fact that there's no exception, no public policy exception to the narrow revenue rule is supported by what Lord Templeman said in Williams and Humbert. I just give the reference, page 428F in Williams and Humbert, Authorities, PA1, tab 5. Now, what is the relevant public policy here? Well, we say, very simply, that public policy requires that victims of an international fraud, assuming we could prove our case on the facts, should have remedies, even if the victim is the foreign revenue authority. And we rely, your lordships put to me earlier this morning, the maxim, fraud unravels all. The authority for that, if one needs it, is Principal Authorities Volume 2, PA 2, at tab number 15, which is HIH Casualty and General Insurance, and the relevant passage is in the speech of Lord Bingham for the House, for the Appellate Committee, and it's on electronic page 10. It's paragraph 15. And his lordship, Lord Bingham, says at the top of the page, paragraph 15, as Lord Justice Ricks observed, fraud is a thing apart. This is not a mere slogan, it reflects an old legal rule that fraud unravels all, fraus omnia corrumpit. It also reflects the practical basis of commercial intercourse. Once fraud is proved, it vitiates judgments, contracts, and all transactions. The principle that my Lord Justice Phillips put to me earlier this morning. Parties entering into commercial contract will no doubt recognise and accept the risk of errors and omissions in the preceding negotiations, even negligent errors and omissions. But each party will assume the honesty and good faith of the other. Absent such an assumption, they would not deal. What is true of the principal is true of the agent, etc., etc. So that's the principle, and it was cited with approval much more recently by Lord Kerr for the Supreme Court, the late Lord Kerr, in Principal Authorities 5, PA 5, stroke 38, tab 38. PA 5/38, the case of Takar and Gracefield Developments, and Lord Kerr for the court addressed the matter at paragraph 43, which is on page 24, and his lordship set out what Lord Bingham had said. Paragraph 43 on page 24, the quotation is set out at 44. This reflects the basic principle. The law does not expect people to arrange their affairs on the basis that others may commit fraud. And we say, in very simple terms, that for the courts of this jurisdiction to refuse to consider the substance of the fraud allegations in this case would serve only to encourage fraudsters in this country to target foreign public bodies, confident in the knowledge that no claim could be brought in this jurisdiction. And we draw attention to one other authority in this context. It's in PA 6, volume 6 of the principal authorities, PA 6 at tab number 41. Recent decision of this court in NatWest Markets. And it's the opening page, page 2, opening substantive page, page 2, the judgment of the court, Lady Justice Aspin, Lady Justice Andrews, Lord Justice Burse. It's what they say at paragraph 2. Whenever a situation creates the opportunity for large amounts of money to be obtained dishonestly, especially at the expense of the revenue, criminals will be swift to take advantage of it. That's the public policy concern, assuming, of course, that we can prove our substantive case. For all those reasons, we respectfully submit that the wider public policy branch, if that's the right word, of Dicey Rule 3.1 does not assist the respondents in these proceedings. I suppose I ought, out of an abundance of caution, just to add that if this case were to go further, were to go to the Supreme Court, then we, of course, would reserve the right to dispute that there is a wider public law principle that goes as far as Mbasogo and the Iran case accepted. And we do that because we note that in Umbasago, the appeal committee of the House of Lords gave permission to appeal, but the case was settled. So the matter was never argued in the appellate committee. That's what I want to say on ground one, subject to one further point that I want to address, and that's the reliance that is placed by the respondents on international tax agreements. Your lordships will have seen that my friends rely on the EU Mutual Assistance Directive, that's MARD, and also other similar, though not identical, international conventions. Although again, it's not their case that there is some exclusion of alternative remedies point. They're not saying that. And therefore, just as a first point, I would respectfully submit that if
it's just an attempt to head off at the pass, a jury point, isn't it? I mean, it's an attempt to deal with the jury point. This is on your case, fraudsters seeking to escape from any liability anywhere. To which they say, "Oh no, you could have employed MARD."
Yeah, that's their point.
I mean, it's neither here nor there. I mean, you're either right on ground one or you're wrong.
Precisely.
If you're wrong, then
they don't need to have this argument. If we're right in our submissions as to the proper analysis of our claim and the proper application of the Government of India authorities on the revenue rule and the proper application of Umbasogo and the Iran case and the public policy issues on the on the sovereign authority part of it, then MARD is neither here nor there. We also draw attention to the fact that the judge below did not decide the MARD points. He certainly explains what they were, but he didn't decide them, paragraphs 121 and 127. If it matters, and I say it doesn't, but if it matters, and can I just make our position clear, our submission is that these provisions do not assist the respondents in any event. What the international tax provisions, including MARD, apply to is the collection of taxes, claims relating to tax. And if we look at MARD, it's in PA 10, and it's at tab 88. That's where we find MARD. PA 10 stroke 88. And in the preamble, on the left-hand side of the first page, halfway down, there's the first recital, whereas mutual assistance between the member states for the recovery of each other's claims and those of the Union with respect to certain taxes and other measures. That's the context. And that's made clear by Article 2, which is on page 3. On the right-hand side of the page, Article 2, halfway down, scope. This directive shall apply to claims relating to the following. A, all taxes and duties of any kind levied by or on behalf of a member state or its territorial or administrative subdivisions, including the local authorities or on behalf of the Union. B, we see the word refunds, but then we look at the context. Refunds, interventions and other measures forming part of the system of total or partial financing of the European Agricultural Guarantee Fund, the European Agricultural Fund, etc., including sums to be collected in connection with these actions. C, levies and other duties provided for under the common organisation of the market for the sugar sector. 2, the scope of this directive shall include administrative penalties, fines, fees, surcharges relating to the claims for which mutual assistance may be requested in accordance with paragraph 1. And then over the page, page 4, fees for certificates, interest and costs relating to the claims. My submission, in brief, is that none of that is applicable to the pleaded claims by SCAT in these proceedings. These are not claims for taxes or duties for all the reasons I identified earlier this morning. Indeed, they're not even claims relating to taxes, since there's not, never was, any tax due from these people. In the context of this case, there is no tax to relate to. And I say the international agreements, MARD is one of them, but the international agreements, if it matters, have nothing to say on the subject of a claim to recover overpayments of a refund that was obtained by fraud. And indeed, there is actually authority that supports that argument, that assertion. It's the decision of the US District Court in the SCAT litigation. If we could go back, please, to PA 7, stroke 57. This was the judgment of District Judge Lewis A. Kaplan, volume 7, PA 7 stroke 57, and the judge deals with this matter. I think I read it out earlier this morning, but I'll read it again. It's on page 27, electronic page 27. It's the last 4 lines. where the judge says the US-Denmark treaty, which we've got in the bundle if we need it, and its provisions for, quote, assistance in the collection of a revenue claim are irrelevant because the plaintiff's claims do not seek to collect tax owed by the defendants and covered by the treaty. And then he sets out what the agreement, the treaty does cover. They cover, together with interest, costs over the page 28, additions to such taxes and civil penalties, income tax, and other taxes imposed under the Hydrocarbon Tax Act, as well as similar taxes. Money obtained by fraud, says the judge, from SCAT is none of these things. And he's right in my submission. So this, with the greatest of respect, is a very red herring in the circumstances of this case. It's irrelevant, and in any event, on its merits, it doesn't assist the respondents in these proceedings. And that's true of all of the instruments on which they rely. The same point can be made in relation to all of them. And in any event, if it matters, none of them impose a mandatory obligation to use such a remedy, even if it did exist. And my lords, that's what I want to say on ground one.
Right.
I notice that there's, it's 5 to 1. Your Lordship may prefer to stop and start again at 5 to 2, or I'm very happy to.
I thought it's just after 5 to 1. You say 5 to 2.
5 to 2, yes.
Okay.
It's a natural break.
It is indeed, Mr. Chairman. 5 to 2 then, please.
Thank you very much.